Question number 101. Section 91 Indian Evidence Act requires that when terms of a contract or grant or other disposition of property is required to be proved when they are reduced to a document, then that document itself has to be adduced as evidence. But then if we see adoption deed is neither of them, so that may be proved by oral evidence. Question number 102. Section 95 Indian Evidence Act says that when the language is plain but unmeaning with respect to the existing facts, the other evidence can be adduced apart from the deed itself. Now in this case, when A says that my house is in Mumbai, but there is no house of A in Mumbai, the house is there, A owns a house but that is in Pune. The other party can adduce the evidence that the house is owned by A in Pune and not in Mumbai, and thus that sale deed relates to the house in Pune and not in Mumbai. Question number 103. Section 114 Indian Evidence Act talks of raising rebuttable inference of fact, that is may presumption, in the common course of natural events, human conduct, public and private business. So once it is shown that there was some false entries in the register, an adverse inference can always be drawn by the court that he intended to dispose them in black market, and that shall be a rebuttable inference of fact under section 114, a may presumption by the court. Question number 104. This question is based straight upon section 121 illustration A of the Indian Evidence Act. So the option shall be B. Question number 105. Marks on the ground produced by struggle at the place where the offence was committed is relevant under section 7 of the Indian Evidence Act. So the option is C. Question number 106. Now it is by virtue of section 25-26 that a confession when made to a police officer even in the immediate presence of a magistrate shall not be admissible against the maker of it. Had it been made to any other person, not to a police officer, in the immediate presence of a magistrate, then it would have been admissible. But when section 25 bars a confession made to a police officer, section 26, even in the immediate presence of a magistrate, shall not make it admissible. So the correct option is B. Question number 107. Section 85A Indian Evidence Act talks of electronic agreements. Question number 109. When the person whose statement was so recorded believing it to be dying declaration under section 32, but if he survived, the statement shall be considered as his earlier statement, and if we see all the options given, it is option B, that his earlier statement can be used as corroborating the statement which he comes and makes in the court. So the correct option shall be B. Question number 109. It is straight away based upon section 45, so the correct option shall be D. Question number 110. If we see judicial notice and the admitted facts need not be proved, so it is only the relevant fact, that is option C, which is required to be proved.